Thank you, Sangeeta. I extend a warm welcome to all the curious students from our college and even outside who have shown interest in the subject, especially faculty members. And we're glad that this workshop is well participated. Now our college principal, Professor Dr. Harpreet Kaur, who's herself a keen researcher and a strong academic, has enormous experience in writing and publishing. Ma'am has always encouraged her faculty and staff to engage themselves in ethical writing and publishing by providing the whole pool of academic infrastructure to the faculty and students in terms of enriched library, e-access to books, journals, and anti-plagiarism software Orkund, organizing several ICT-related FPPs and workshops. That has definitely enriched us all in effective writing. Several of us still have queries regarding the copywriting of the published work or even the much talked about issues related to plagiarism, which will be addressed in today's session by Advocate Ankit Sahni. I would now request ma'am to please give the welcome address to the audience and especially welcome our guest of the day, Advocate Ankit Sahni.
Good morning. On behalf of Research Board, I extend a very warm welcome to our guest, Mr. Ankit Sahni, who is an advocate and he has a rich experience in the field of IPR. And so I welcome you, sir, for joining us. And also I extend my welcome and really appreciate my team, starting from Dr. Harleen Kaur, Dr. Lokesh Gupta, Dr. Harinder Sandhu, and all others who are a part of this research board and who have been doing quite a lot to attach our students with this concept of research and propel them to do more research and delve into this entirely new field, which according to me is very challenging. It's very interesting also, it is very challenging also. But once you go into this, I think there is no limit to it and you will enjoy also so many things, because after all, doing research gives you a kind of a push also, and it is also very challenging and very interesting as well. So that is why I always say that the students must come out and they should do quite a lot of research, because those countries which are doing research are somewhere way ahead, and those countries who are not focusing on research, their growth, their entire things are lopsided. And so we must understand the emphasis of research and the kind of countries, and also nowadays the companies are putting in a lot of money into this research, especially the marketing research, and that is why they are surviving and thriving in this market-oriented economy. So research is imperative everywhere, wherever you go, and understanding research issues and related issues are very important. What I believe is when the printing press came, there was a lot of change in the entire scenario of printing, and people started reading more and they became more enlightened. Before that, few copies were written, and few copies could not be distributed, and people would not read much. But with the printing press coming into existence, a lot many changes came in, and people, and we moved to this concept of modernity, for that matter. So now what is happening with the concept of internet and communication technology, ICT technologies, is changing the entire scenario. The things of doing research and printing things have become much more simpler. Of course, simpler because you, at the click of button, you get a lot of information. Earlier we had to go to the libraries, go to the site, or go do the research and from the scratch, but we could not find many leads there. But nowadays things are very simple. But if the things are simple, it is also complicating the issues. It is complicating the issues because you have so many things at the click of button that it confuses you, and many times you are unable to understand that where you want to lead and what you want to do. So you have to make this information into a kind of a knowledge, purposeful knowledge, and try to be very very specific that this is what you want to do. But then again, when you start writing or doing some work or doing a piece of maybe art or anything, there are so many varieties which are there, and everybody knows about them very very like it's very, very openly. And so if you try to do this and something comes in your work which is related to it, it becomes a problem. So you have to be very very cautious that you are not using the piece of other person, whether it is in writing or whether it is in other things, and you have to mold the whole thing. And but sometimes it becomes difficult also because when whatever you read also impacts your mind. And so when you start writing or doing something, it is already there in your mind, that particular idea. But how to make it novel, of course you start research from some point, but how to make it more novel, and that is what is required. And for this, all those concept, IPR issues and patent issues which are coming up, because sometimes unknowingly or unknowingly you misuse or use of art of artwork or piece of literature produced by someone else, then those legal issues come up. So you have to be very cautious about it. The important role is there of your concept also, and your organization might also help. But you have to go very systematically by documenting everything you do very very properly, because sometimes you have created something but you are not documenting it properly. It might be used and misused by somebody else. Be careful when you are using those non-proprietary materials or someone else's work you are using, how you have to use it. Of course, there are certain concepts that how you can use the others' work with due references and citations. So all these things are very clear. So if you are using someone's work, give due regard and due recognition to that person. And also sometimes there are some certain contractual arrangements also between the company or certain other things. So abide by them also, otherwise they will lead to legal issues also. And so your potentialities can find a new vistas, and you can learn about new things. So no doubt you do things, think about it, delve into this concept of research, and which is very feasible if you do it in a systematic manner, and you will not land up in trouble. And I think Mr. Ankit is specializing in those legal issues where people might land up into certain problems, and he would tell us certain cautionary measures which should be taken while writing something or doing some other work. So, and he has been expert member of European Observatory on Infringement and Intellectual Property Rights. So with this IPR becoming important after WTO, So WTO has changed the entire scenario, and these issues have come up so openly. So that is why we must know about the issue also. We must know the legal issues into it also, so that you are careful when you are doing work, and when you're doing work under individually or under the aegis of your company, but very specifically you are doing it in a manner which is not ending you into some kind of trouble, and also giving you due recognition. So those things are very important when we are doing such things. And within under the research board, we have been trying to train the students into new things. We have given them some research assignments also. They have come up with new things, and it's very, very interesting. And all the research board members, along with the other TIC, they have been really doing quite a lot, and the committee is doing quite a lot. So we are making the base, that how students were, because they might further pursue PhD or do a certain others research even as a part of your organization. So we are trying to make the base of the students, so that they are comfortable when they go out into the field, and they know the nuances of it, and they're very cautious while treading on this very cumbersome path. So happy kind of new things, and you are delving into new things and have a nice challenging things ahead, but learn quite a lot. And with this words, I really thank Ankit Sahni, and I'm looking forward to listening to him also. Thank you all.
Thank you, ma'am, for setting the stage for the discussion. Now, I would like to introduce our resource person for the session to the audience. Advocate Ankit is an award-winning intellectual property and technology lawyer. He represents clients in a diverse array of enforcement, contentious, and transactional IP and technology law matters covering a variety of industries. He's also retained by some of the world's largest Fortune 500 companies as counsel to enforce and defend their IP rights. And his practice is well recognized by the industry and media, for which he's been awarded the International Client Choice Award for Trademarks, which is recognized by the World Trademark Review 1000. He's also featured as a legal rising star in 2021 and recognized as one of the super 50 lawyers in India by Thomson Reuters. He was also a finalist in the ALB India Law Awards 2020 in the Young Lawyer of the Year category. He is the only Indian lawyer, to be appointed as an expert member to the European Observatory on Infringement of IP Rights, a regulatory body that functions as a policy think tank for the European Commission. He was also invited as an expert witness by the Parliamentary Standing Committee on Commerce while reviewing the intellectual property rights regime in India. His list of achievements at this age is still, I mean, it's very long and applaudable, I must say. And faculty members, those who are engaged in writing of books and papers, are really looking forward to your talk, as all we know is that we should get our manuscripts checked in the plagiarism detector software so that we won't have to face copywriting issues, but perhaps have little idea of what can we do if there's infringement of our work. So I would now hand over the virtual mic to Advocate Sahni for his session. Sir, please start your session. Thank you.
Thank you so much, Dr. Kaur, for that very warm welcome. Despite that very pleasing introduction, I still like to refer to myself as a student of law. And I hope to remain a student of law for very many years to come, because that's the only way one can keep learning and one can keep improving oneself. Also, many thanks to Professor Harpreet Kaur for setting the stage. And I think hearing her welcome note makes me very happy to see that the academia side of the world is so well aware and so deeply engrossed in intellectual property rights issues. I think it's going to make my job very easy. In fact, now I'm in hindsight thinking probably the slides that I prepared for today's presentation. I'll try to build it up as short. So, intellectual property rights is a very diverse field, but we'll try to cover aspects that Dr. Kaur pointed out as regards, looking at some of the practical challenges that staff and students and researchers might face in day-to-day lives, and how to basically add value and ensure that your research or whatever you produce in terms of your intellectual property, your intellectual assets, deserve the protection, the recognition that they're required to get. With the permission of the administrator, I'm going to share my screen, and I'm going to put up the slides that I prepared for today's presentation. Okay, I'm not sure if my screen is visible.
Yes,
to everybody.
It is visible.
Okay, thank you. From the basics now, when we look at the term, we see the term intellectual property. It covers within its gamut of wide variety of different rights. It's basically industrial property in the traditional sense, and it covers copyright, it covers trademarks, it covers patents, it covers industrial designs, it covers confidential information, it covers geographical indications, it covers plant variety protection. So there are so many different fields within intellectual property when we refer to it. And before we move ahead and dive deeper into some of the issues that may be particularly relevant for this audience today, I'd like to quickly go through each of these category of rights, just so that we are all on the same page and we remind ourselves about what exactly each of these terms, which are sometimes interchangeably used by all of us, but each of them mean completely different things. So what exactly do they denote or signify? So trademarks, the most basic way to understand trademarks is brands. So anything and everything that you see around you, perhaps the laptop through which you've logged in is an HP laptop. You may have a Samsung phone. You may be using a Dell printer or an Acer screen. So each of these things is a trademark. Coca-Cola is a trademark. All of these things are trademarks. Then patents are basically the working parts, the arms and the limbs that go into making things around us function. So whether it's something as simple as a zipper, whether it's something as complex as a computer or a mobile phone that probably has thousands and thousands of patents built into it. So patents are basically inventions that are created which cover a particular function that something performs, or several functions that some device, some object, some piece of technology performs. Copyright broadly covers the creative side of things. Copyright has four broad heads, and in one of the subsequent slides, we'll talk more about it. We'll talk about it in more detail. So the four broad heads, and the easiest way to look at copyright is to see it in the sense of literary works, dramatic works, musical works, and artistic works. So paintings, books, research papers, journals, any kind of essays, even answers to your examination questions, all of those things are subject matter of copyright. Dances, dramas, performances, the very wonderful prayer and the performance that we saw at the beginning of the session, the music that was played and performed there, all of those things are subject matter of the copyright law. Industrial designs concern aesthetic things. For example, the sole of a shoe, for example, the shape of a pen, for example, the shape or the contours of a table, of a chair. So all these things cover industrial designs that basically talk about aesthetic aspects of various objects. Confidential information is, as the name suggests, is basically all information which is confidential to you, which you have developed, and which basically is your trade secret by virtue of it being your product or a consequence or a product of your hard work. So therefore, that's also protected separately as a category of intellectual property. Then there are various other categories which may not be so relevant for the purposes of the present discussion. With that, I'll move on to the next slide. Another basic one to understand how to really perceive intellectual property. Now, you see, intellectual property is very similar, but at the same time, very different to regular property. When we call something property in the classic sense, intellectual property is very similar, but at the same time, very different to it. So intellectual property and property, the primary difference is that intellectual property is intangible in form. So you can't really touch or feel brands. You can't feel the goodwill that it has generated. You can't feel or touch or lift or shift, any literary work that you've created, any book, any content that you've generated, any piece of art that you've made, any illustration, because these are all intangibles and they exist in that form. But there are at the same time a lot of similarities to what we understand as classic property. So property could be whether it's movable property or immovable property being a car, brick of gold, mobile phone, wallet, purse, so many things. And immovable property being your home, piece of farmland, so on and so forth, the machinery which is attached to the earth. So the similarities are that like traditional property, intellectual property can also be sold, it can be purchased, it can be licensed, it can be commercialized. You can license it out, you can sell it out, you can earn money from it. It can be assigned, it can also be kept as a collateral or security for you to raise finance. So it is in that sense very similar to what traditional property is seen and understand and recognized as, just so that we know how to perceive intellectual property when we talk about it. The IP chain of activities broadly move in this fashion. Everything starts at the creation stage. When you're sitting and you're thinking of writing a new article or a research paper or a book, that's the ideation or the creation stage. Then you put something in the form of a rough draft, like a framework, and you keep improvising, you keep innovating and keep improving on it, keep making it better. So from creation to innovation, eventually once it reaches the stage or the level where you're satisfied, this is what you would like it to be, comes the point of having it protected, which is most important, because without protection, your creation doesn't mean anything. Every right in the legal sense has an opposite and consequent duty. So a right is only a right to the extent there is a consequent duty or obligation on somebody to respect and protect that right. So protecting your intellectual property rights through the legal process, which also I'll try to touch in some amount of basic detail today, is very important for you to formally apply for your copyright or your patent registrations and to get protection and get a certificate, get recognition by the government. So we'll also try to talk about the protection aspects. The next is commercialization. So whether it's books that you publish, it's a chapter in a book, or it's a paper you present in a conference. Eventually, all of it is your intellectual property, and how you choose to commercialize it and how you choose to, like Principal Ma'am mentioned, essentially things like, practical things like doing marketing research. So any time that you spend in doing marketing research, for example, could be of immense value to the marketing industry today. If your research gives insights in the marketing context, into consumer behaviors, consumer patterns, what kind of things do people like to eat most when they're in lockdown, or what kind of content do people like to consume most, see most when they're in lockdown. All of those things have a very practical value to add to the industry, and therefore you could probably sell it to the industry, you could make a book out of it, etc. All of which leads to commercialization. And the last but not the least aspect is enforcing your rights. Of course, we have instances all the time when people's hard-earned research, their creations are copied by other people. So how does one enforce one's rights, and what are the remedies available in law for infringement of one's intellectual property rights is also an aspect that we will try to touch upon in today's session. With that, I'll move on. Now the question comes, why should IP be protected? Okay, I'm a student, or I'm a lecturer, or I'm a professor in the college. I'm already employed, or I'm a student, I'm learning. I understand that when I write a journal article, I write a book, I author a book, or I present a paper, there is a lot of effort that goes into creating that. But why should I protect it? So protecting, like I mentioned, your intellectual property, your assets is important to give recognition to your ownership rights. Because if you fail to protect it, if you waive your right of being recognized as the owner, somebody else can jump in and misappropriate what is yours, and they may move ahead and commercialize it and gain benefit from it, which otherwise was due to you. So it's important to protect your ownership rights. It's also important because it increases your competitive edge. So whether you're a teacher, or you're a student, or you're a researcher, protecting your creations, again, in the education context, protecting your research, your illustrations, your graphs, your articles, etc., gives you a competitive edge as far as your career is concerned. You can always mention it in your profile. You always get recognized by the amount of intellectual output that you've generated. So it's important from that perspective. Of course, you can always monetize it, commercialize it. Like I mentioned, you can publish a book and earn royalty out of it, and so on and so forth. So these are some of the reasons why it's very important for IP rights to be protected, especially from the broader perspective of overall industrial and creative growth of the society. It's important for all of us to be wary of our IP rights and protect them. Moving on very briefly to give you an idea of the legal framework which is there. Now, each of the categories of rights that we talked about has a consequent act that the lawmakers have made against it. So the trademarks are protected under the Trademarks Act 1999, patents are protected under Patents Act 1970, copyright under the Copyright Act, and then below that there are rules, there are regulations that govern some of the procedural aspects. Then there are international treaties to which India and other governments, other countries are a member. Some of the very important ones for the purposes of today's discussion, and we'll be briefly touching upon those as well, are the Berne and the Paris Convention. Then, of course, there are case laws, judgments that the court gives. There are policy documents that the government takes out, or vision documents, so on and so forth. So this is basically the entire framework, the legal framework of how intellectual property rights are protected and enforced. With this overall introduction, I would like to deep dive into the first topic of our interest, the one which is probably most relevant to this audience, to this group today here, which is copyright. Now, what exactly is copyright? Now, copyright basically, as I mentioned in the beginning, protects 4 buckets or categories of things. It protects literary works, it protects dramatical works, it protects musical works, and it protects artistic works. It also gives protection to photographs. It also gives protection to sound recordings, which is nothing but songs, and also to cinematograph films, which is nothing but videos or movies or shows, etc. So what exactly, let's start with the first category. What exactly is a literary work? Now, a literary work is anything which is put in writing. Now, it may or may not be, it may or may not appeal to every person. Copyright law makes it very clear that what you create by virtue of your own efforts is what is protected by copyright. Now, what you create may not make much sense to a second person, to a third person, or someone else, because it is so subjective. This field, whatever somebody paints, if an artist paints something, an artist paints three horses, that may appear like nonsense to another person, but to another person's eyes, it may be very, very aesthetic, very beautiful. So copyright law is very neutral in that aspect. It renders protection to anything and everything which is created as a consequence of a person's efforts. So for literary works in the academic or research context, all your research papers, your essays, your projects, your articles, your books, your even your, like I mentioned, the answers to your questions which you give in the exams, all of those things are protected as a literary work. They are your creations. You have written them. They are original and novel in their identity. They have come out of your pen or out of your mind, and to that extent, they are given protection under law. Similarly, we have protection for artistic works. Now, again, artistic, like I said, need not be of the level of a Picasso or an M.F. Hussain or anything. If I take my pen or a pencil and I doodle at the back of my register, that also is protected under law as an artistic work. So anything that you create artistically, visually, whether it's a pie chart, graph chart, or it's a painting, it's an illustration, each of these aspects, or if it's a logo or anything of that sort, anything which is visually represented is and forms subject matter of protection as an artistic work under the Copyright Act. Similarly, we have musical works. So musical works, of course, is not the sound or the voice or the singing aspect of it, which is protected separately as a sound recording. Musical copyright is basically the musical notes that go into composing a particular song. So the rhythm or the notes which are there is basically what amounts to sorry, I just saw a prompt in the chat box. Okay, it's about questions. I'll continue. Of course, if anybody has any questions, subject to the program convener's discretion, they can be answered either during the session or at the end if we have some time left. I'll continue in the interest of time. So musical works, again, being the musical notes which one creates, which form subject matter of protection. And dramatical works are basically drama. So anything you perform in your college amphitheater, any dance, any play that you perform, the performance of any dance or a play by itself is an act which is protected as a dramatical work under the Copyright Act. So these are the different buckets of rights which Copyright Act protects. Then there is sound recording in cinematograph films, and these are sort of secondary or derived rights. And why they're secondary or derived rights is because they are formed from a combination of one or more of the earlier rights that we talked about. So let's take the case of a sound recording. A sound recording is basically a combination of a literary copyright as well as a musical copyright. Literary, how? Because the lyrics of a song are protected as literary copyright. And musical, how? Because the music that gets played from the notes that the performer of that particular music, if let's say somebody's playing a tabla or somebody's playing santoor or sitar, they're following a note sheet, and the musical notes that go in that note sheet is protected as a musical work. So therefore, sound recording is a secondary or a derived work from the primary kinds of works that are protected under Copyright Act. Same with cinematograph film. So cinematograph film would be, again, a combination of perhaps literary because the dialogues in the movie would be protected, or the script of a movie would be protected as a literary work. The background score, the music is protected as a musical work. The performances, the dance performances that come or other performances, those are protected as a dramatical work. So there are different combinations of the primary kinds of works that come together and form the cinematograph film secondary or derived category of right. Then comes the question of what exactly is protected. Now, like I said, anything and everything that you write is protected. but what is the right way to perceive or understand what exactly gets protected under law? Now, there's a very important principle, very important doctrine under copyright law called the idea expression dichotomy. Now, what this doctrine says is that copyright law would ordinarily never protect the idea by itself unless that idea is expressed by being fixed in one form or the other. So the idea could be, for instance, Surya Namaskar. That's an idea. Now, there cannot be a copyright over the idea of Surya Namaskar by itself. But your performance of Surya Namaskar, now, if you Google, if you go to YouTube and you see, you would be amazed to see there are probably some 25 or 30 different kinds of videos, at least, that come up where people have followed the same Surya Namaskar steps, but they have done it in such creative ways that while it does look like Surya Namaskar, but each performance, so to speak, is so different from the other that that you're really amazed to see what kind of creativity people are doing. So while the idea by itself of doing Surya Namaskar cannot be protected, but your expression of that idea, which is unique to you, and the expression has to be fixed in one of the four forms that we mentioned. So it has to be either fixed in literary form, or because in this case it can be fixed in a dramatical form. So basically, the performance of a Surya Namaskar or a Surya Namaskar inspired dance or whatever it is, those are all dramatical performances, and therefore the expression of the idea is what is protected under copyright law. Another important aspect to understand for all of us is the concept of an author. Now, the copyright law refers to the creator of each of these categories of rights: literary, dramatical, musical, artistic, sound recording, cinematograph, film, as authors. Everybody is called universally an author. So it's not just somebody who writes something, but any person who creates something is called an author. Now, ordinarily under copyright law, the author is presumed to be the first owner of the copyright. So whoever creates something is presumed to also be the economic owner of the rights that vest in that particular creation. So then we'll, in the next couple of slides, we look at the exceptions, especially in the context of how a research board would work or how a college works, a department works. What are the exceptions to this rule of the author being the first owner? There are circumstances where the author need not be the economic owner. They will obviously have the right to be recognized as the author, but the copyright in what they create would eventually lie with somebody else. We'll just come to that in a minute. Before that, also important for us to learn is what is the tenure of protection that copyright gives us. So the tenure of protection is generally the lifetime of the person who has created what is being created. So the author in this case, and then after that person's death, another 60 years. So it's a very long period of protection that the law provides you. And in most cases, if you see very interesting examples like books, Enid Blyton, or other authors who have passed away, their families, because the right continues 60 years after their death, their families inherit the right to receive royalties on their behalf. And that is how they get rewarded for the creations that their predecessors, their forefathers did before them. So this is, the duration of protection that law is accorded to copyright is very clearly significant of the fact that the lawmakers treat it as a very important category of right. They encourage more and more people to be creative, to create things, and in reward for your creation, for your efforts, they give you protection over this right for your lifetime, and then after you pass away for another 60 years, so that your children and further generations can benefit from what you created. There is no requirement for registration, but registration is advisable. It is a must. Why there is no requirement for registration is because universally copyright law is designed in a manner that it gives protection. It gives protection to a piece of work the moment it comes into creation. And this is followed in more than 200 countries of the world. This is where the Berne Convention comes in, which I earlier mentioned about. So the Berne Convention is one of the most important international copyright treaties that most major countries of the world have entered into, the Berne Convention makes it obligatory for the 200 odd countries that are member to the convention to render automatic protection of copyright to all member countries. So for any particular work that gets created in one country, which is given copyright protection in that country, that particular work is also automatically rendered protection in all other 199 odd countries. Same way, if there is a work that gets created in, let's say, United Kingdom, that will equally be protected well in India if the person is to enforce their rights. So in your context, any articles, journals, anything, any paintings, illustrations that you make, anything which is protected as your copyright, although you're creating it in India, but you automatically get recognition of your rights. If tomorrow you have to move to the United Kingdom, or you learn that somebody in the United Kingdom or in some other country is actually copying your content, what is protected by copyright, what was created by you originally, you can always move, court in that country, and you can sue that person to enforce your rights and to get appropriate remedies which are provided for under law. So the moment you create something, the moment you author a research paper, it is rendered immediate protection, and immediate protection not just in India, in 200 odd other countries of the world which are member of the Berne Convention. Then we come to the definition of copyright. Now, when we refer to the term copyright, what exactly is the nature of the right? So the best way to perceive it in the classic sense, as jurists have talked about it now and then, is to see it as a bundle of sticks. So copyright is not a single right. It is a bundle of sticks, or a genus of rights that are bundled together. Now that bundle comprises of infinitely many rights. Some of the more important rights I have tried to mention on the screen. So one very important right, of course, which comes under that bundle called copyright, is the right to reproduce. So the right to reproduce is retained by the person who owns the bundle, the entire bundle, called copyright. So obviously, if somebody else, some third party, tries to reproduce what you have created without your consent, you have the right to stop them. And they have an obligation to abide by what you say, because you own the right to reproduce what you've created. You also own the right to communicate the said work to the public. So if you've composed a drama and you perform the drama in one theater, you also have the right to perform the particular drama, the particular theatrical work in n number of theaters across the world, to also perform it on television, to record it and keep it to be broadcasted or performed in the future. So the right to communicate it to the public is also retained by the owner of the copyright. Then the right to make adaptations. So let's say somebody comes up with the story or a novel. Now, if your friend reads that story or novel and decides to create a play out of it, they may argue and say, look, a lot of creativity has gone into making a play out of what was a plot in a story or a novel. So therefore, the play by itself is my own independent creation, and I have not infringed your copyright. It is correct to say that the play by itself is an independent creation and could be subject matter of copyright protection. But because the right to make adaptations of your work is a right that you retain, any adaptations that are made without your consent will be considered as an infringing use of your creation, of your copyright. Therefore, if you write, using the example that we were talking about, if you write a novel or a story and somebody makes a play out of it, that will amount to infringement unless it enjoys your consent, in which case that play by itself will also qualify to be a separate work and therefore subject matter of protection under copyright by itself. Then I know the professors at Mata Sundari would also deal with a lot of translation. There are a lot of religious books of importance that are being continuously translated. So translations of works. So of course, religious books, there's no copyright in religious books. They belong to everybody. They belong to everybody in general. They belong to everybody in general who belong to a particular faith. So therefore, as far as religious books are concerned, there's no copyright. But if I write a book in Gurmukhi and somebody translates that or parts of that let's say, a few chapters of that and publishes them in the United States or in some other country, that would definitely amount to an infringement, because copyright as a bundle of rights also contains the right to control the translations of the work, which if somebody makes, of course, again, the same argument can be put, and somebody may say, look, there's a lot of effort that goes into translation. So therefore, what comes out as a translated work also by itself on its own legs can stand and be protected as copyright. But again, the test of whether it infringes somebody's copyright, existing copyright or not, has to be seen. So if it doesn't enjoy your consent, it cannot form subject matter of independent protection. If it enjoys your consent, then of course it can form subject matter of independent protection. So translation is also one of the rights which form the core bundle of rights, which is referred to as copyright. And like I said, it's an infinitely large bundle. There are n number of rights that you can think: rights to make novels, comics out of it, rights to make movies, rights to make dance forms or be inspired. I mean, there's so many things that can come out of this. So the bundle is not limited. There can be n number of rights that can be imagined. For instance, the right to receive royalty. So if I want, I can assign one or more rights by retaining the rest of the rights with me, but one or two or three rights I can assign to somebody else. So let's say if I have a friend and the friend tells me, look, you're a very busy person, you keep writing research papers. Why don't you assign me the job of collecting royalty on your behalf? I will invest time in collecting royalty by approaching publishers, selling or assigning or licensing your work to such publishers, and whatever revenue gets generated from that, I will collect all of that. I will streamline it, put it together, and I will share it back with you. For that, I'll share a small percentage of the profits as fee, and I will remit the rest of it back to you. So in doing so, when you enter into such an arrangement with a person, you're basically assigning or giving up your right to collect royalty in favor of your friend, who will then manage it. But that doesn't mean you've given up on the entire bundle of rights, which we call as copyright. You're only taking out one or two rights out of that bundle and giving it to your friend so that it can be managed better, etc., whatever the purpose may be. So this is the best way to perceive or see copyright in this context. Coming to the next aspect that I intend to cover in this session is very important, especially, like I said, in the context of how the research board or IQAC or how the college works, etc. Now, like I said, as per Section 17 of the Copyright Act, ordinarily the first owner of the copyright is the creator of the copyright herself, the person who has created that copyright. But there are certain exceptions to this rule. The number one exception, a very important exception, is if you're in the regular employment of an entity or a government body or a college or a private body, etc., and what you create falls within the four corners of what your scope of employment is, your employer will be deemed to be the economic owner of the copyright that you create. So if you're employed as a university lecturer and you compose a song, or you draw a painting, or you write a book, ordinarily, if the subject matter of the book falls within the four corners of what your scope of employment is, the copyright would by default belong to the employer. Unless you seek permission, unless your employment or service terms or contract says anything to the contrary, it will be presumed that your employer owns the economic rights. Two important things emerge out of that. One is for us to pay attention on the fact that it has to be within the four corners of your scope of employment, which means if I am, let's say, a mathematics teacher, but I write a fiction book on whatever subject, that fiction book arguably would not fall within the four corners of my scope of employment, and therefore, in that context, the university or the college may not be able to claim any economic rights over the novel that I've created, the fiction novel, the fiction work, because I haven't done it. It isn't a work that I've done within the scope of my employment. It isn't something for which the college is paying me for. And therefore, it will be deemed to be your work, and not just you being the author, but you also being the owner of such work. The other important thing to bear in mind is that if there is any arrangement to the contrary, such arrangement will override this legal provision. So if you take a waiver or you take an express consent from the head of the institution, from the person who's authorized to waive such a right, whether it's the dean or it's the university or it's the principal of the college, whatever the case or circumstances are, such waiver will override this law which is provided in the Act itself. So these are the two important things to bear in mind. There's also because Madhusundari is a University of Delhi college, and I presume it receives grants from the government, from UGC or from one or more wings or instrumentalities of the government. There's a very important provision which says in case of any public address, speech, or any other work which is made by or delivered by any person pertaining or belonging to a government or public undertaking, then such person or government or public undertaking will be the first owner, again, in the absence of a contract to the contrary. So anything which is delivered at this platform, on this forum, by a person who's regularly employed by the government or any undertaking or a body which is considered to be an extension or instrumentality of the government, will be considered as belonging to the government. So this is important for all of us to bear in mind for the various works that we create, so that we have clarity on what works are we entitled to commercialize, what works are our employers, the university or the college, entitled to commercialize, and that picture then becomes very clear from there. Again, like I promised, I'm going to very briefly go through the process for copywriting. This becomes, so generally it is advisable to take help of someone who's a lawyer. You may not, it's not something so complex that you need to engage a lawyer for this. With sufficient amount of time being invested, probably if you go through the rules, a lot of it has been simplified and put up by the government on the Copyright India website. With a couple of hours of investment of time, one can get the hang of how to write the application and how to follow the proper steps to submit it to the authority, which in this case is the registrar of copyrights. But it's still advisable to take legal help. The broad steps are very simple. The first step is, once you have your creation in place, you have your book, you have your something as broad as a source code of a software, if you've created something, to a painting, to a digital image or digital painting, to an article, whatever be the nature of your creation. Once you have that in place, you have to file an application. There's a specified form under copyright rules, which is called Form 14. You have to basically mention your details, such as who are you, you're the author, what is your address, are you resident in India, is this work published, unpublished, if it was published, when was it first published, what country, what place was it first published, is there any other person who may have any rights or who may be interested in the subject matter of this. So this could be anybody who may have helped you. So if you're a lecturer who's prepared a research paper and you've had one or more of your students support you, so potentially the students may be interested in the subject matter because they've contributed, and they may get recognition under law as a co-author. So if you decide to file for registration of copyright for that paper in your own name, you may not be allowed to do so, because if there are other people who have contributed, the law recognizes their right to be recognized as well as joint authors or co-authors of a particular work. So you have to give them notice, and you have to also include their names in the registration process, because eventually when the certificate gets issued, it gets issued not just in your name, but it gets issued in your name along with the names of the other people as joint authors or co-authors who have contributed to the creation of something. So again, first step is filing for this. Then you generally wait for the officers there to examine, to scrutinize your application, which generally takes about 30 to 60 days, given COVID times. If there is any objection, they will let you know. Then you get a period of 45 days to get over the objections, the discrepancies, and satisfy the officers that the discrepancies that they pointed out have been
We've lost you, Ankit. Ankit, we have lost you.
Ma'am, you might have to call him,
I'll just do that.
or I'll just check if I have his number.
Just follow. Maybe a power outage or something. Probably a power outage. We've lost you. Oh, yeah. He says he's joining. Probably a power outage. So, whew. Yeah. He said he's joining. हाँ जी बेटा. Okay. Harleen, he can't unmute himself. Sangeeta?
Sangeeta, please.
Sangeeta, the speaker can't unmute himself.
I'm doing.
Okay.
Brief interruption. I had a power outage at my end. Now I'm back online. I hope you can see the screen.
Yes, we can.
Okay. So so coming back to the process, I think you lost me somewhere in the process. After we file the form, we wait for the office to examine it and issue a discrepancy report. We get a period of 45 days to address the discrepancies, after which it gets published. And if nobody from the public has got any objection to this getting registered in our favor, it eventually proceeds to registrations. So the entire process would generally not take more than 2 to 3 months from the date you apply for it to the date you get your registration certificate. The fee for applying has been kept at a very nominal figure by the government. So the fee per application per work is 500 rupees. And you can pay it online through UPI or net banking, etc. And it's very simple to file copyright entirely online. And your registration certificate also gets emailed to you at the email that you provide along with the application. So, so this is in brief the process. Now we come to another very important topic of exceptions to infringement. Now, exceptions to infringement has been a very controversial topic since long, and some of the aspects about exceptions to infringement in the teaching or academic context are also spoken about by the principal, by Dr. Kaur in the beginning in a welcome address. I'd just like to briefly touch upon those aspects as well. And then we'll come to a couple of recent cases that came and got highlighted in a big way in the media. Cases from the Delhi High Court, incidentally. So now what are the exceptions to infringement? So we talked about all the rights that you have, the duration of the right, what comprises of the rights, what are the different kinds of things that comprise of the bundle of rights, which is called copyright. How can you stop somebody from doing something, so on and so forth. But there are a very widely described set of exceptions to infringement of your rights which are given under law. Some of those exceptions are particularly relevant in the academic and research sense because they have been drafted and inserted in the law by the parliament with the view to specifically protect the use in the academic context. So the first exception is for private use or research. Now, what this basically means is if there is a book that you have in the library, if you decide to photocopy a few pages or a chapter, and you decide to keep it with you, or you decide to make 2 copies of that, or 3 copies if you like, one for you to redline, another clean copy for you to compare, and so on, whatever the purpose may be. Now, those things, for as long as they are limited to your private use and your private use for research purposes, you will not be considered as infringing the copyright belonging to the author whose books you're photocopying and keeping. Not the entire books, we'll come to that aspect as well. But let's say 1 chapter, 2 chapter, or as many pages as you like for the purposes of your research. The second very important exception given under law is infringement or exception to infringement for the purposes of criticism, review, or comment. Now, let's say if there is a book that you're doing a critique of, you'd like to critically analyze that book. And for the purposes of doing a critical analysis or a review or a commentary on that book, you have to reproduce certain passages, certain parts of that book. Now, if this exception were not to be there, it would ordinarily amount to an infringement, right? Because you're reproducing parts of somebody's creation, which is obviously their copyright, whoever has written that book, and you're reproducing it in something that you're writing. But because you're doing it for the purposes of reviewing or commentating on it or doing a critique of what they've written, for the said purposes, the lawmakers have provided for an exception to infringement. So if you do it for this purpose, it will not be considered as you doing something wrong in law, because it's protected as an exception. Then the third important exception is that if there is anything that a teacher or a pupil uses in the course of instruction in an educational institute. So in an educational institute is not written in the statute itself, but basically it is construed or to be understood in the context that this is a teacher teaching a pupil, or a pupil responding to a teacher's questions, etc., or pupils interacting amongst themselves. And in their interaction in a teacher-pupil classroom kind of environment, if anybody reads out or puts up on their screen or on the projector or on the blackboard or anywhere parts of or passages of, let's say, a book, ordinarily it would be exception, but because of this, ordinarily it would be infringement, but because of this exception which is given under law, it is not considered as an infringement, because the lawmakers realize it would make it very difficult to promote education, because copyright is basically a social legislation. Social legislation, because it has 2 competing needs to fulfill. One need is the need for the recognition of the rights of the person whose investment has gone into creating something, the hard work, the sweat that has gone into creating something for the benefit of others. So that person's creation must be protected, and that person must be incentivized to keep creating more by giving him such protection, right? Because if there was no exclusivity, if there was no copyright, why would we be incentivized or encouraged to write more things? You would not even be half as encouraged or be half as incentivized if somebody was to say कि ठीक है आपको आपका नाम लिख देंगे, लेकिन you will not be entitled to stop somebody from copying it, or you will not be entitled to publish this or get recognition or whatever. So the law has to balance between incentivizing and rewarding you versus the right of the society at large to get access to this and get your feedback and learn from what you have done. So these 2 balancing rights, the copyright legislation tries to protect by providing for these exceptions to infringement, out of which this is one important one which the lawmakers recognize, that if we were to not include this exception, how would education happen? How would teachers and students be freely able to refer to passages from books, or be able to critique pieces of art, people who are in fine arts, be able to critique pieces of arts belonging to different people without putting up that piece of art in front, or to be able to discuss the styles and this and that. So in the interest of promoting education and access of the society to these resources and for the society to progress, this exception was inserted. Again, similarly, if you reproduce passages from a book, from a study, anything, as part of the questions, that the teacher frames or as part of the answers that you give to such questions, again, it will not be considered as infringement. The performance of something in the course of the activities of an educational institution. Now, this exception is also important. So let's say if there is a subject or there is a course in arts, let's say, which is about, or let's say there's a mass comm or media course. Now, in the mass comm or media course, the teacher tries to teach to the students various different aspects of, let's say, how VFX or visual effects, special effects work. So they play a particular movie. Let's say they play an Avengers movie or a Disney movie, which are known across the world for their special effects. So the act of playing that movie, of course, is an infringement by itself, is an infringement of the copyright vested in that movie, which probably belongs to Pixar or to Disney or whichever producer or production house owns the copyright in that movie. But because you're doing it in a classroom environment, further to the regular activities that educational institution of this kind would do while they're teaching. So of course, if a maths teacher takes a class out for a movie, or let's say a maths teacher uses the college auditorium to play a Disney movie, that by itself would not be treated as an exception. That would probably come under an infringement and be considered as one. But if it is a mass comm teacher or a literature teacher that wishes to show Mary Poppins so that students appreciate the dialogues that have gone, or the finesse of the visual effects that have formed part of the film, then it will be treated as an exception to infringement of copyright. So with that, we move on to the two recent cases that I talked about. These are very important. There have been many cases, of course, but these are two which made it to the news for obvious reasons. The first one is University of Oxford versus Rameshwari photocopy. This is a Delhi University case that many of us may have read about. Why it's important is because in recent times, this is the only case where the issue of photocopy shops that operate outside campuses, outside colleges, or even inside colleges that give free access to prescribed course material to students. We all walk up, at least, 9 years or 10 years ago when I graduated from law school, till that point in time when I used to go to our university's photocopy guy, he used to have a lot of photocopies or even digital images, back-to-back PDFs of different course books stored in his photocopy machine in the hard disk, which was there. And we would sometimes just come with a pen drive, or we would come with a request, pay him some rupees and say, okay, give us 2 chapters of this book, or give us 4 chapters of this book, or whatever. And he would simply just look it up on his machine and be able to produce copies, bind it, and give it to us. Now, this is precisely what Rameshwari photocopy shop was doing outside North Campus, Kamla Nagar area, basically. And it got sued by University of Oxford, basically OUP and CUP, Cambridge University Press, and Oxford University Press, for the books that were getting reproduced by the photocopy guy. Eventually, the Delhi High Court single judge held in favor of the photocopy person by referring to the same exception which we talked about 2 minutes ago under section 52, which is by a teacher or a pupil in the course of instruction. So the judge said that because this is meant for consumption by a teacher or a pupil in the course of instruction, it will be considered as an exception to infringement of copyright. Of course, eventually the matter went into appeal, and because of a lot of protests from students and teacher bodies, etc., the Oxford University Press and Cambridge University Press decided to withdraw the matter without prejudice. But that was the last judgment that came out, which did say that the photocopy person was not liable for infringement because this was being done at the instance of teachers or students and meant for consumption in that context. Similarly, there's another matter which is currently going on, very recent. This was filed in December of 2020, which was filed by Wiley, Elsevier, and a few other publishing companies together against 2 very popular websites, one being LibGen and another being Sci-Hub, who proudly refer to themselves as pirators of scientific journals and academic journals, And so these websites, in the name of allowing people to get access to paid journals, have uploaded back-to-back photocopies of the entire journals, the entire books, volumes of journals or independent books on their servers, which you can freely browse and download as PDF. Now, the challenge with that, and why Wiley has decided to approach court after the University of Oxford judgment came out, despite that, is because they feel that there is a major distinction between how Rameshwari photocopy shop and other photocopy shops function versus how Sahab functions, because Sahab is accessible to everybody. Rameshwari photocopy shop was in North Campus, so there was a reasonable basis to presume that majority of the people who would visit there would be students who are asking for these books, because these would be books which are prescribed as course materials, and they would get photocopies for their personal consumption and also for discussion in classrooms, etc. But Sahab is a website, as a URL, is universally accessible. So even if I'm not related to the academia or education field, I can also get access to these journals and download them, in which case it would amount to infringement. So for these reasons, Wiley, Elsevier and others have decided to sue Sci-Hub, LibGen, and one or two more websites which are there, but these are the two more popular ones out of all these websites. This is still a pending matter, so it's still going on. Probably it'll make sense to watch out this space to see more developments and see how the Delhi High Court reacts in this particular instance. But last development is that an association of students has intervened in this matter, saying they want to be heard because this concerns them as well. And this Sci-Hub is a very important resource for them, because they get free access to journals which are otherwise very expensive and even very difficult to obtain from university libraries that may not have that kind of budgets to afford such journals. So these are some recent cases. Another important thing for if there is somebody from the library team here, perhaps also for principal ma'am to see. Now there is the concept of copyright societies in India. Now copyright societies are nothing but they are a creature of law. They have been given a special purpose. Copyright societies make it easy for the collection of royalties on behalf of publishing companies or on behalf of individual authors, because authors are not businessmen as such. It'll be very difficult for authors to keep collecting royalty. So the law provides for copyright societies, not just in the publishing context, in every context. So there are different societies. For singers' rights, there's a different society. For performers' rights, there's a different society, and so on. In our particular context, the Copyright Society for the publishing field is called the Indian Reprographic Rights Organization. And what they do is, this is not very well known because they don't publicize this very much, but they are open for business, of course, for an amount as little as 20,000 rupees plus GST. This is an annual fee for the entire year. For a college of more than 1,000 students, you will get access to all the titles from all the publishers who are members of this copyright society. So generally, if you go onto the IRRO website, you will see most major publishers have signed up, whether it's Tata McGraw-Hill or it's Pearson or it's the likes of Wiley or Nielsen, etc. So all of their research, their reports, their tests, their other things, books, journals will be freely accessible to your entire college student body as well as faculty. And this is actually the legitimate way of getting access to content because this society is empowered by the publishers and the authors themselves to license this content out to you. And they have made it very simple, very accessible for educational institutions. For commercial use, of course, the fee is much larger, but for educational institutions, they are mindful and they've kept it at 20,000 rupees. The only condition being that in one instance, you can only photocopy maximum 15% of the pages of a particular book, cover to cover, or one chapter, whichever of the two is higher. And there's another condition, which is that the photocopy machine, wherever it is kept, whether it is a captive machine kept inside the library or this is a standalone photocopy shop, must keep a tab of all requests that have come, the name of the person requesting, and what were the number of pages and the name of the book, of course, or the work that was photocopied. So this is something for the library people to see, probably, or the principal to take a call on. IRRO already has a lot of subscribers. So most IITs, IIMs, certain other institutions and colleges, universities are all subscribers to this annual fee, and they get access to all titles hassle-free. Completely from the repository, which is there on the IRRO website. They have a list of titles and publishers who are members. So that, and then some other checks and balances for us to keep in mind. Most important suggestion, which wherever I deliver a talk or a lecture, I always give, whether it's whether it's a private body or it's an institution. What is very important is for the institute to develop and design an IP policy or a SOP, a standard operating procedure to handle these kind of issues. So there must be an IP policy in place, and the IP policy will look after both aspects of IP that is created within the college, so that it is ensured, because when you realize, you think of it, you do an exercise, you go back to the college, do an exercise, you will realize the college may be sitting on dozens and dozens of intellectual properties or assets, which so far may not have been monetized properly or may not have been registered or recognized properly. So it's important to have an IP policy in place, under which or in accordance to which the research board or the staff or the researchers and everybody function, so that they're able to disclose what they create. And also there is a check and balance in place to ensure that any person who's doing it, like I mentioned, within the four corners of their scope of employment, do not try to personally appropriate that for their own benefit. Because that will ordinarily belong to the college. So it should get registered in the name of the college, and so on and so forth. So that, and the other half of the policy, ensuring that the students and the staff make photocopies and use copyrighted material, whether it is by way of citing this in their research papers, etc., or it is for the purposes of presenting in a class, or for the purposes of viewing, reciting, or whatever, reproducing it in any way. They do it in a manner which is compliant with law. So having an IP policy in place is a must. Another quick couple of points, best practices, is to review your employment agreements with ad hoc staff, with researchers or part-time people who are not ordinarily governed by the government service rules or the University of Delhi service rules. So any employment agreements for contractual people or any vendors that you may have on site for any purpose, their agreement should be vetted to ensure there is no leakage of intellectual property which otherwise belongs to the college, for it to be misappropriated by any such person under the circumstances. So with this, now we have more, of course, because like I said, it's a very vast subject. I'm not sure how much time we have, but I'm going to take a pause here.
Okay if we wind up, because there is another there is a lecture which people have to, there is a valedictory which people have to attend.
Of course. So I think we can break up for questions. With your permission, I'll just like to refer to one single slide, very important, which pertains to infringement and the remedies that you have against people who infringe. This is just to break the ice, a funny slide which I tried to put in place, calling it in nature, it's obviously we call them twins, but in IP law it's called infringement, having an identical copy or substantially similar copy of another. So very quickly, through the remedies and through the deterrence which is provided under law. So basically, when we talk about infringement is an act of violation or unauthorized use or exploitation of a person's statutory rights to exclusively deal with their intellectual property, as we discussed today. If your rights get violated, you have two kinds of remedies under law. You have civil as well as criminal remedies. So for civil remedies, you have the right to approach court and file a case for injunction. So injunction is basically when a court directs a person to refrain from doing something. So you can get an injunction order from the court. You can also ask the court to award damages in your favor. You can also ask the court to instruct somebody to perform a search and seizure of infringing articles which are there. If somebody's made a copy of your articles or books which are unauthorized, they can be seized. So this is the civil side of things, and criminal also, because it's also a criminal offense under the Copyright Act to be infringing. So you can file an FIR for which there is imprisonment up to 3 years and there is a fine. So with this, I'll take a pause in the interest of time, and if we have time to take questions, perhaps we can take one or two more questions and then conclude at that.
There is a colleague who has asked, Sci-Hub still continues despite the fact that the matter is in the court.
Yes, so that's a very pertinent point. Thank you so much to Garima for pointing that out. Sci-Hub continues because despite Wiley and Elsevier approaching court, the court so far has not been convinced to grant an injunction. Like we said, one of the remedies which we just talked about, the court has not granted an order of injunction stopping Sci-Hub from continuing business. So the court is still hearing the matter and they haven't granted an injunction yet. And for those reasons, Sci-Hub and LibGen continue to be accessible.
So can we ask, would you be kind enough to answer? I would mail the questions to you if you would be kind enough to answer them.
Of course, of course.
So, Harleen ma'am.
Hanji ma'am. Okay. Again, Dr. Garima has another query, and she says, could you elaborate on how one can attain Creative Commons license for one's work and what protection does it offer to the author?
Sorry, can you repeat that question again, ma'am?
She asks that, could you elaborate on how one can attain Creative Commons license for one's work, and what is the protection that it offers to the author?
Okay, so contrary to the concept of protection, Creative Commons is a genus of open source licenses. So if you create something, ordinarily the copyright of what you create vests with you. But when you decide to share your work pursuant to a Creative Commons license, you're basically making it openly accessible to the people at large. And different Creative Commons licenses would have different terms. There are many variants of it. But for instance, let us take an example of a share-alike Creative Commons license. So a share-alike Creative Commons license means that you're opening it up to the world at large to share it, but it has to be shared alike on the same terms with which you opened up your content. So it's a copyleft concept or an open source concept. There are no rights. In fact, by agreeing to give up your work on Creative Commons terms, you're giving up on your rights. You're giving up over your copyright over a particular work so that it can be shared more freely with the world at large.
Just like we have open access policy in the journals, right?
Yes, yes. So in a similar way, if one wants, by one's consent, one can agree for their work to be shared pursuant to a Creative Commons license.
Thank you. And I think Jasnoor's query has already been answered by you in your slides. And we can just take up Dr. Manisha's query. And her query is, I'll just read out. What do you think about the gap that is created by protection of IPR vis-a-vis access to the general population? For example, speaking from a student perspective, they don't have access to international publications. I think this also relates to Sahib, etc. in India because of the current practices of the developed world. Do you think there are any solutions to making such things accessible? Paywalls are exclusionary, especially to the third world or people who aren't from top tier colleges.
So at the risk of saying this, I will go ahead and say it. Paywalls are an illegal tool that companies, publishers are using to stop people from getting access to content. I say this mindful of the fact that I represent a lot of publishers from the industry, but I'm personally of the view that paywalls are illegal because the law as it stands today, when we were reading section 52, provides a number of exceptions to copyright, which means if you're a student, if you're a teacher, and you're utilizing a particular work for the purposes of education, for critiquing it, for private research, you're entitled to use it, and that act by itself would not amount to an infringement. So therefore, paywalls is a major issue, of course, that has to be tackled. A very easy solution, and I would emphasize again on that fact, is if one subscribes to an IRRO license, it's 20,000 rupees per annum, and it gives you access to a wide variety of titles. And there are very good publishers who ordinarily offer their journals at a very expensive rate, who are also members of the IRRO scheme, and therefore it's probably the cheapest way to get access to all the content and to be able to photocopy it, subject to the conditions.
I think Garima wants to seek some clarification. So,
thank you, Arlene, and good afternoon, everyone. Good afternoon, Mr. Ankit. Firstly, I'd like to say that it was really, really informative, and therefore the kind of clarifications. You've said that this Creative Commons is for sharing your work with in the larger public domain. Now, what I want to seek to clarify is that once you get the Creative Commons license, firstly, what are the, if you could answer at a later point in time also, what are the modalities for obtaining one? And once I have that, what protection does it offer to me? For example, if the dissertation is put up by the university on the website of the university for everybody to benefit, then what is the kind of protection as a researcher that I get for the fact that my dissertation is there for everyone to see and benefit? And what would constitute as infringement? Those are some of the clarifications. I hope if time permits, you can, probably give me some kind of insight on that, or probably at a later point in time as you deem fit.
Thank you so much, Garimaji. I'll try to be very brief in the interest of time, and I leave my contact details with Dr. Sandhu, and I'll be happy to take this conversation offline. But like I said, there are dozens of different kinds of Creative Commons license variations, and assuming you were to agree, so there's no formal place or forum where you apply for a Creative Commons license. As the creator of your thesis, again, I'm not particularly aware of service rules, etc., but assuming your service rules entitle you to own the economic rights in your thesis, you will be considered as the author and the owner of the copyright in your thesis. Now, whatever dilution that you do from this point onwards, as regards the accessibility of your thesis, or as regards who all can download or copy it, or in what manner can it be copied, downloaded, or shared, is totally up to you. So if you agree to share your thesis on one or more of the variations of the Creative Commons license, one variation is which requires you to, which requires the person who's downloading it to continue to give you credit. And also, when they share a copy of your thesis, they ensure that it goes with the same set of conditions to the person it is being shared to. So this could be one variation. Another variation is a very liberal one, where the person says, I don't want to be identified as the author also. I will make it accessible to anybody to share it in whichever manner. They can mutilate it, or they can extract paragraphs also and then share it alike, or they could delete portions of it and share it alike. So there are different terms and conditions which are completely dependent on the person who agrees to give up his rights from his bundle of rights called copyright, and to what extent you would want to give up those rights is on you again.
Okay. Thank you so much. In case I have some kind of a query, probably I'll request Dr. Sandhu to share your email ID. It was really, really insightful. Thank you so much.
Thank you so much. Thank you.
I think I thank you so much, Advocate Sahni, for your insightful talk and this interaction also. It was very, very enriching. I would now request Madam Dr. Harinder Sandhu, the convener of today's session, to present her vote of thanks.
It's a pleasure to deliver a formal vote of thanks to one so young and yet so dynamic and accomplished. As I thank our young illustrious lawyer, I wish to invite all the colleagues in sharing our pride in this young stalwart achievement. He is the son of a fellow colleague from DU, so we can all partake in victorious joy and vicarious satisfaction. Detailed, incisive, clearing misconceptions around commonly held beliefs and disbeliefs. So in line with your familiar tradition of excellence and perfection, Advocate Sahni, you've done a great job. You are educating us on copyrights, on adaptations, the spin-offs from our creations, and topically relevant inputs about religious books, about translations, and about religious literature, of which our principal has a lot to contribute. So educating us on filing of copyright, on exceptions, which are very, very critical to us as teachers, and on designing SOP and IP policy. I think Lokesh sir and Dr. Harleen, as conveners of IQAC and research board, would like to look into it. So thank you so much. Thank you so much for sparing time, for sharing valuable insights. You are as loquacious and erudite as you are knowledgeable. So I would like to thank you from the bottom of my heart on behalf of the principal, the IQAC, and the research board of Mata Sundari College, which takes me to deliver a formal vote of gratitude to our principal, who's encouraging, who's a visionary in terms of where academic work should lead us. And we are joined by a very illustrious team in our IQAC, headed by Dr. Lokesh Kumar Gupta, committed to the students, committed to research, committed to excellence in research, and most importantly, very, very passionate about involving students, which is amazing. And thank you so much, Ankit Sahni, for enlightening us about what we can do with our work with our students, because many teachers collaborate, as you rightly said, for research with their students. Thank you, Dr. Harleen Kaur, for thinking of this and doing this. Thank you, Dr. Manisha Mathur and the entire technical team. And most of all, thank you so much, all of those who joined in today. You have enriched yourselves, and I'm sure you would also go ahead and distribute this knowledge elsewhere. So with these words, may I ask Dr. Lokesh Gupta